Anyway, since we seem to be out of witnesses, I thought I'd drink a little.
Hey, Tyler. How's it going?
Good, Rob. How you doing?
Good. It's
Good.
been a busy week. Things seem to be picking up in the office or in my home office, I guess. How about yourself?
It's been crazy. This was a little bit of a hectic week, but yeah, same old.
Well, cool.
Yeah.
We've made it to Friday afternoon, and we talked a little bit before we got online about what we want to chat about today. We haven't shaved today because I'm in the home office. Excuse me, but and I'm just sick to death of COVID, so I don't want to talk about it anymore.
I'm not even going to say it.
Good, I did it, so that's the end of it.
That's it.
Okay.
So we talked about it, and I've been talking to you a bit about this. I've got this kind of new fun little project I've been working on. I'm going to open up some seminars soon for people who don't have lawyers, what we usually refer to as self-represented litigants. And the seminars are going to sort of help people to navigate the system. And I'm going to have kind of a variety of topics, and it's going to help people navigate the system without the necessary retaining of a lawyer, or maybe not on a full scope anyway. So anyways, let me get into it. So when we deal with a couple that are separating.
Oh, wait a minute.
Yeah. Oh, right. We don't want to forget.
Straight law cocktail. Recipe's online again.
Where is it online? Where do you have the recipe?
It's on our website.
Oh, right. Yeah. Okay. hdplaw.ca.
Yes. So if you want to try a straight law cocktail, go to our law website and it'll show you how to make a drink.
Perfect.
Nothing else. You get that out of our website. So I apologize for interrupting.
No, not at all. Cheers.
Cheers. What are you drinking today?
I am back to an old fashioned. This one I have a little piece of orange rind in it. Away from the ginger today. We got some fresh oranges. So.
And I've got my maraschino cherries. So
beautiful.
Hands over here. So I'm sorry I interrupted you. We were talking about your project and self-represented parties, and
I jumped the gun a little. So anyways, yeah. So that's a little project I've been working on, and I'm going to base it on this theme that when people break up after a relationship where they've kind of commingled assets and income, or maybe had kids together, they kind of face typically what we would refer to as 5 issues. And sometimes there's issues underneath those or adjacent to them, but the 5 issues are typically parenting, child support, spousal support or partner support, division of property, and then at times the divorce itself. And in our experience, we've talked about this, and typically we're seeing a lot of our clients come to us and want that divorce action started because eventually they want to get the divorce, and these other issues are along with that divorce. And so I'm going to kind of do my seminars based on that, those 5 issues, and I'm going to kind of go to sort of this how to do it mechanism. And so today we thought, wouldn't it be fun for us to go through a statement of claim for divorce and see how we fill that out and why and how that works. So Rob, why don't you show us where to get a statement of claim template and what we do with it?
Well, so in Alberta, and we should probably point out, the Divorce Act is federal, which means the legislation itself applies from Nova Scotia to Victoria. However, every province has its own procedures, which means their own forms. And so the forms in British Columbia, as you discovered last week, are very different than the forms in Alberta and so forth. So we're talking about Alberta divorce. If you're watching this podcast or this YouTube video and you're in Saskatchewan or Manitoba, this really won't be a ton of help, but it might be similar. It probably is going to be similar, but your forms are clearly going to be different. So if you're in Alberta and you want to start a divorce action, the first thing you're probably going to want to do is you're going to go to albertacourts.ca, www.albertacourts.ca. And that's the basic website for all the courts in Alberta. And then you're going to go find the Court of Queen's Bench. And so maybe I'll just, I'll share that screen just for a moment so you can see what the Alberta Courts website looks like. So are we seeing that?
I see it now, yes.
Yeah, so here we are at the albertacourts.ca. You can see the address up there. Now, the divorce matters commence in the Court of Queen's Bench. So this red website portion in the middle, you point where it says Court of Queen's Bench, and you're going to click that. And it'll bring up something that looks like this. And so this is the Court of Queen's Bench website. Now, in a perfect world, it would say forms right here, but it doesn't. So you got to go hunt around a little bit. So you're going to go areas of law, and you're going to say, okay, family. So I hope you could follow that. Areas of law, family, family law, forms. Now, there are some instructions for divorce forms, but we're sort of giving that to you right now. So just go to family law forms, and you click that, and it brings you up this. And then what you're going to look for, you're going to go scroll down here. Now, as you've said, Tyler, usually you got a divorce, and you also got to deal with some property issues. And so you may want to start a statement of claim for divorce and division of matrimonial property. Now it's actually family properties since January. But for now, we're just going to talk a statement of claim for divorce. Simple, simple. And we'll find out it's not quite as simple as you would like. But statement of claim for divorce. So why don't we just click on download. And we can open that up. And so what the Court of Queen's Bench in Alberta has done is they have provided fillable PDF forms to make it a little bit easier. So that's a good thing to start with. So, so we can see that. Now, as you kind of go through this, you'll see these little blue areas. Those are the things you basically need to fill out. So
at the top there under court file number, let me hop in. You wouldn't fill, you don't put anything in yet because you don't know what your court file number is going to be. You leave that blank. The clerks, when you go to file this and pay your $260 filing fee, they're going to fill that in for you. They'll give you a number at that point.
Yeah, so your action number starts once you've filed your document. They assign a number, and that will be the number for every document you ever file in that action. You're in the Court of Queen's Bench of Alberta, but there are several judicial centers in Alberta. So you got to select one. And as you see, there are several judicial centers. We are in Lethbridge, so we would click Lethbridge. If you happen to reside in one of the other judicial centers, you would click on that. So far, pretty simple. Now, before we get into the next stuff, I'm going to stop sharing this just for a moment so you can see my lovely face again. A word of advice. Before you commence your action, I would order a marriage certificate. Now, a marriage certificate is issued by the government authority where you got married. So if you were married in Alberta, you're going to order a marriage certificate from the Alberta government, and you can get that from a registry center, basically anywhere in Alberta. If you got married somewhere else in Canada, then you're going to want to contact those jurisdictions and you want to get a marriage certificate. And the reason is, too often, even occasionally for lawyers, we'll commence an action and we don't have the particulars correct. The way that people filled their names in on their marriage certificate is how they want the divorce action resolved. And so you want your statement of claim for divorce to mirror what your marriage certificate says. Now, if you happen to have been married outside of Canada, you can't rely on your certificate. You have to do a thing called, ultimately, when you actually apply for your divorce, prove the divorce and solemn form. We won't get into that today. If you wanted a little more information on that, we'd be happy to reply to that if you want to send us an email. So before you fill out the plaintiff, my advice is get a marriage certificate and make sure you got your name right. Because I've had many divorces where people say, you know, my name is John Robert Smith. And then we get the marriage certificate and it's John R. Smith, or it's just John Smith, or it's Robert Smith, or it's Bob Smith. And what'll end up happening is you'll have to amend your style of cause later. And it's just another headache that you don't need. So start out right, get the marriage certificate and get your information to be exactly the same as your marriage certificate.
On that note, I've had a few funny ones where my clients have the date of the marriage wrong. So yeah, get that marriage certificate. Not a bad idea.
Yeah, that happens. So just following on the form, and I'll just describe it for the moment. So you got plaintiff, that's the person starting. That would be you. The defendant, that would be your spouse, the other party. And again, you want that name to be just the same as it is on your statement of claim, or I mean on your marriage certificate. Sometimes people say, well, I want to sue my husband's girlfriend. Under the Divorce Act, you can't add another party without leave of the court. And typically there's no point in adding co-defendant being a paramour or something like that. You only want people in the action that you need relief from. There are occasions where we'll add other parents, but you don't need to worry about that. We're just talking about your straightforward garden variety divorce. So defendant is your spouse. Address for service is the next thing you're going to fill out, and that's going to be where they're going to serve documents. It is worthwhile to know, once you file this, these people are going to serve you at that address. And I've seen situations where self-reps don't understand that you don't need to get personally served with anything once the action has been commenced. And so it's up to you to make sure that you check that location for documents. So if you get served with some sort of an application a week or two down the road, there's no excuse to go, well, I didn't check my mail. So make sure the address is accurate and make sure that you regularly check for mail. And your contact information, you have to have a phone number. If you have access to a fax, you should put a fax number in there. You can put an email address in, but again, you better be monitoring that regularly if you're going to use email.
And it doesn't hurt to have, kind of good rapport with the other party or their lawyer so that you make sure you're all in constant communication with anything that's going to happen. Yeah,
exactly. So we're kind of going to go through this. A little bit of it's mundane. We're going to get into some issues, though, that are going to be a little more interesting and confusing, maybe is a better word. So you're basically following along your marriage certificate, date of marriage, where you got married, and the place. They don't need an address. Lethbridge, Alberta, Calgary, Alberta, Cardston, Alberta, Las Vegas, Nevada. Just basic. When did you start cohabiting? If you lived together before you got married, the court wants to know how long did you live together before your marriage. So you're going to have date of marriage. You're also going to have date of commencement of cohabitation. And then when did you separate? Now, what does separation mean, Tyler?
So separation can be a little bit tricky. Oftentimes, and make it really clear, is going to be, well, you don't live together anymore, but that's not always the case. Sometimes you can live together and still be living separate and apart. So the court will often look at several factors to determine what that is. But a really good way to define what your date of separation is the date that one party communicated to the other that they wanted to live separate and apart for the purposes of obtaining a divorce. Yeah.
So it's not uncommon that people file statement of claim for divorce and they're actually staying in the same house.
Not uncommon, yeah.
A good rule of thumb is, are you sharing a bedroom?
Although not necessarily, but that's a good rule of thumb.
Not necessarily, but if you're sleeping in the same bed, that's probably a little problematic to assert that you're separated for reasons that we'll get into as we go on. So when did you end your relationship in the sense of you were no longer living together as husband and wife? You're not sharing meals, you're not doing duties for each other, you're not sharing a bed, you're not intimate.
Not wearing your wedding rings.
Of separation.
Yeah.
And then again, there's some mundane information, but it's important to get it accurate. What's your address, date of birth, place of birth, surname at birth? Fairly self-explanatory. What was your last name the day you were born? Surname at date of marriage, that could be different. Sometimes you have a second marriage and you're still using your ex-husband's surname. And what was your marital status? Now, I have a bit of a sort of a bugaboo about this because I've seen people say single. Single doesn't mean anything. Single means, I guess I'm not married. I still use archaic terminology. If you're a woman, you're a spinster. If you're a male, you're a bachelor if you've never been married before. If you've been married before, you're divorced from a previous marriage. you can't be married at the date of your divorce, that would be called bigamy. And even in southern Alberta, that's illegal.
Okay.
Even in the state of Utah, as far as I understand. Little dig, my former partners are all Mormon. And the same.
Of course, with good fun, we're just having a good time.
Yeah. So you gotta fill all that stuff out. Residence. So the plaintiff or the defendant, and you fill in either or, has been ordinarily resident in the province of Alberta for at least 1 year immediately preceding the date of the statement of claim. That is rather important, but sometimes ignored. So I have seen lawyers that file a statement of claim and their client's been in Alberta for 3 months. They've moved here from Saskatchewan or British Columbia. And the problem is you don't have jurisdiction and you can end up losing your action. You lose your action and the other spouse files a statement of claim in Saskatchewan or BC. You got a big pain in the neck because now you got to travel and get lawyers in that jurisdiction. So don't try filing a statement of claim of divorce if you haven't been ordinarily resident in Alberta for at least 1 year before the day you file it. If that means you got to wait, wait. Now, if you have an urgency, you can seek relief under other legislation, under the Family Law Act in particular, if you need a parenting order or a support order. But don't commence a divorce until you've established jurisdiction. And why is that, Tyler? Why do they care? Why is that part of our statement of claim?
It's part of our statement of claim because, of course, you don't want to have competing actions, right? So you don't want to have somebody filing in BC and in Alberta, and you want to be able to deal with the property wherever the property happens to be, and that you have to have the court has to have proper jurisdiction to deal with the property issues. And of course, it'll matter as to where the children are living if there's children as well for jurisdictional issues and for, well, what are we going to do with these kids?
Yeah, and my sense is we've got separate jurisdictions across Canada between provinces and territories. And inherent in that is the idea that people could be filing claims in different places. And the courts waste enough time and resources as it is without having people commencing an action and they've been in Alberta for 3 days.
Yeah.
Just have the court have to make a formal order moving the action back to British Columbia or Saskatchewan. So the concept is, if you're going to file a claim, you have to have pretty clearly established that you've got some connection to this jurisdiction. Mm-hmm. For reasons of efficiency, but also for reasons of fairness. If you've been married for 20 years in British Columbia and you're in Alberta for a week, you shouldn't think you're going to carry the divorce out in Alberta. So that's why that's there. Then you got to establish grounds. And I always find this kind of curious, personally. You can't get a divorce because you and your spouse go, I break with thee, I break with thee, I break with thee. Right?
A little harder to get a divorce than it is to get married.
Yeah, right. You want to get married, it's like, are you married? You go, yeah, get married. You want to get divorced, you need approval of the crown, right? Some judge has to anoint you with his blessing for the termination of your union, which is based on grounds for divorce. And the grounds for divorce in Canada are that you've been separate and apart for a period of at least 1 year by the time the divorce is concluded. Now, it's important to know, we talked about jurisdiction. You can file a statement of claim based on a 1 year separation, even if you've only been separated for a week. But you can't use a 1 year separation as a grounds for divorce until you've been separated a year. So a lot of people will file for divorce inside of a year, and then they wait the year and then they file. Because at that point, there's no need for further evidence other than advising the court in affidavit form, typically. I've been separated and apart for over a year. Now you have grounds.
So to be clear, you can file the statement of claim even though you haven't been living separate and apart for a year, but you can't get the divorce granted until the year of separation.
Based on 1 year separation. Now, right. There are other grounds for divorce. Adultery is still a ground for divorce. So in theory, you get a divorce in a month if you can establish to the court evidence of adultery. And we joked about this offline a little bit. Adultery is a very specific thing. It is having sexual intercourse with a person other than your spouse without their consent or approval. So if you're into wife swapping adultery during that event,
not going to work for you to get it.
There's no work for you. And it's interesting. I've had a lot of people want to claim divorce based on adultery. And I'll say, what's the evidence? Well, I found this girl's phone number in his phone. That's not adultery. I drove by her house and his car was there. That's not adultery. You have to establish on the balance of probabilities that your spouse had sexual intercourse with a person other than yourself. That is difficult to do.
Yeah, it is.
Now,
in fact, it's so difficult. I don't think I've ever actually got a divorce on that ground before. And to think about what it is you'd have to prove, I actually go back to my law school prof, who's now a judge, and I have to think, well, what did she say it was? And there's, balance of probabilities. You got to be able to prove that probably happened.
Now, the only times that I typically allege adultery is when the other party is prepared to admit it.
Right.
In a formal way. And so, but even that, I had an interesting file, man, it's probably 20 years ago now, where my client was alleged to have committed adultery and the wife wanted a divorce, and he said, that's fine, I don't want to argue about it. And so the affidavit was filed, and my client filed a statement saying, I acknowledge that I had sexual relations with a person other than my wife without her knowledge or consent, prior to her date of our separation. And this went to a judge who's now passed away. And the judge rejected it, saying there's insufficient evidence to establish adultery. Right? And so, being the smartass that I am, I prepared an affidavit, and my client was happy to participate. And I literally wrote it out like a Penthouse forum letter.
Oh, geez.
And it was kind of something like, I was having drinks with friends at a local watering hole, and I saw this woman across the bar. She looked at me and smiled. I looked at her and smiled. I went over and bought her a drink. And after some small talk, I suggested that we leave and go to my home. Well, I was very happy when she said yes. Upon entering our home, after some small talk, I began to kiss her on her neck. And from her neck, I undid the top of her blouse. So basically, I had about a 12-paragraph affidavit going to explicit detail about what he did with this woman. The divorce was granted. The judge later just asked him if he enjoyed her affidavit or not. But suffice to say, it's got to be particular to establish sexual intercourse, and very hard to prove without an admission. Now, there are cases where people have hired PIs and they've got photographs of people in flagrante delicta, it's an old legal term, in the act, exhibiting what can be assumed to be relations, but hard to do. The last ground for divorce, and I've used it quite commonly, is mental or physical cruelty of such a kind as to render intolerable the continued cohabitation of the parties. So tell me about that, Tyler. What do you typically tell your clients when they ask you what cruelty is?
Yeah, so I mean, it's got to be, again, you got to be able to prove it, and you got to be able to prove it to the degree that, of course, it would be intolerable to live together. So typically, unfortunately, psychological type of badgering and whatever probably isn't going to constitute it. Of course, the courts do take physical assault pretty seriously, sexual assault's taken pretty seriously, and there's got to be sufficient proof. Now, I also always tell my clients, especially if they're already living separate and apart, chances are good that this divorce is going to be processed at least a year out from living separate and apart in any event. So we can allege it, but we can typically rely on the fact that they all have lived separate and apart for a year prior to the divorce being granted.
But I think it's important maybe to let people know, if you don't want to wait a year, and sometimes people don't, and sometimes people are actually getting married again.
Yeah, there's a good reason, yeah.
Insane, but it happens. I would highly discourage it. But what I usually say to clients, and I've probably done more of these than you, it has an objective and a subjective element. And the objective element is is the treatment that you are complaining of treatment that most people would find to be offensive or something you shouldn't have to tolerate? So to use two examples, my spouse punches me in the face. I don't think there's anyone in the world that would say objectively, why are you complaining? But my husband chews with an open mouth. Okay, some people would find that offensive. Is that the kind of thing you shouldn't tolerate in a relationship? Hard to say. So there's the objective element.
And we hear a lot of things on that continuum, on that line.
Now there's a subjective element. So once you've established that these are the things this person has done that most people would find to be offensive and not tolerable, how did it affect you specifically? What was your subjective experience? And this is where you say, okay, they did this, that, and the other thing. And this is how it affected me. This is how I felt. And typically, I've never had a divorce rejected on grounds of cruelty, not once in 34 years, because I pay attention to that objective and subjective element. And the subjective element, and you don't make anything up. You don't put crap in there that's not true. But the subjective element typically is, I was depressed. I withdrew from friends and family. I lost weight. I gained weight. I had to go on antidepressants. I was receiving sleep medication because I couldn't sleep. My employers asked me on frequent occasions why I wasn't concentrating at work. So there's some subjective exhibition of it was hurting you. And if you marry those two things together, you're probably going to be able to establish cruelty based on even what might be called mildly offensive if it's a perpetuating thing. I had a judge I was tootling around with that once said to me, you give me any marriage of more than 5 years in duration, you put on one page everything that person did that hurt your feelings and made you feel less than, you're going to establish grounds for divorce. And so the reality is, if you want to get a divorce inside a year, very few cases am I not going to be able to make a case out for cruelty, because people typically don't get divorced when they're happy. So that's grounds. And then you have to declare, is there any possibility of reconciliation? And the form with the Court of Queen's Bench doesn't even give you an option. That's just already filled out. So if you're filling this thing out, there's no possibility of reconciliation. You can't get a divorce if you're thinking about maybe getting back together, is the theory. Now that then leads to bars for divorce. Remember we talked about you can't just make stuff up. You have to declare that you have not colluded to get a divorce. So with respect to 1 year separation, you can't just go, well, let's just say we've been separated a year, and then we'll get a divorce. Because that would require you to swear an affidavit, and you can't swear a false affidavit. Well, you can, but then you open yourself up to a charge of perjury, which probably isn't worth the extra 6 months or something, and you're getting your divorce quicker than you otherwise would. If your allegation is adultery or cruelty, you have to also indicate, and it's basically an X box, that the plaintiff has not connived or condoned the grounds complained of prior to bringing the action. Again, that doesn't apply to 1 year separation, but if you've alleged cruelty or adultery, you have to check that box. And what that basically means is you didn't encourage your spouse, so you didn't go to a bar and go, that guy's a pretty good looking guy, you should go sleep with him. That doesn't work for adultery. Condoned. Maybe you're into kinky sex and you like it when your spouse spanks you. That's not cruelty. So you can't encourage or approve of the treatment you're complaining of. That is very infrequent, but you have to still declare that. And again, the whole point is, and I find it, I don't know what your thought is, Tyler, I find it kind of ludicrous, the idea that the government is still in our bedrooms. Pierre Trudeau once said, the government has no place in the bedrooms of Canadians, and yet there they are. They're telling you that you can't get a divorce because you want one. You need the approval of some judge, and there are certain judges, and we know who they are, that don't like divorces. And so you may establish grounds, and they're still not going to give you a divorce right away. So There it is.
Yeah, you know what? Fair enough. There is a long history as to the involvement of the government in marriages and divorces. You know, and I think it was in 1977. Prior to that, there was no such thing as a no-fault divorce. You had to have either adultery or cruelty. So it's a long history. We won't get into it, but there it is.
Yeah, in my case, I graduated law school in 1985, and Divorce Act, new Divorce Act, then new, came in 1985, but there were still divorces that had been filed prior to 85. And I remember the first couple of years, you had to go to court to get a divorce, even if everything was agreed to. And you'd put your client on a witness stand, and they would have to get up in front, and uncontested divorce court was a busy place. And you had to get up on the witness stand in front of a bunch of people, and God forbid you're alleging cruelty. So now you're going to give evidence in front of a bunch of strangers as to what your husband or your wife did that made you feel small. Now, since 1985, you can, if it's not contested, you can get a divorce by affidavit evidence. You just submit these documents to the court. My take is it resonated still with religious objection to divorce.
Yeah, I think you're right about
Still
that.
felt that the constitution of marriage had a solemnity that should not be easily terminated, in some religions more than others. Catholics, for example, very opposed to divorce. And so the government, fighting as they do with their own popularity, was dragged into the 21st century, and they're still not already there in terms of, look, I don't want to be married to this woman or man. I'm not sure why I need a judge to tell me that's okay, but there it is.
And behind that, there's this idea of public policy, right? Where we want to value the institution of marriage. We don't want to break it up very easily. But then on the other side, there's public policy. Maybe it's shifting or changing. Maybe it's always been there that, of course, we don't want to keep people in relationships they don't want to be in, or tied in these economic unions they don't want to be in, or whatever. So maybe public policy is changing, or maybe it was always
Well,
there.
I mean, it's the same bullshit that we heard when people were objecting to gay marriage.
Right.
Oh, the institution of marriage is the foundation of society. And when you do divorce work for, I don't know, 20 or 30 years, you see how little people really respect the foundation of marriage in some cases. And so I always found that a little bit offensive as being used as an argument, because it was on the marriage issue.
True.
Anyway, we digress.
Let's keep going.
Then you got to fill out particulars of your children. And any child in which you have that the other spouse stands in the place of a parent. And tell us about that, Tyler.
So look, essentially the court's just going to say, look, upon the breakup of a relationship or a marriage in particular, we want to make sure the kids are cared for. And they want to make sure those kids are cared for by way of child support, payable usually from the non-custodial parent to the custodial parent. And they don't care whether that parent is the biological parent or what we call someone who stands in the place of a parent. If you're stepdad or stepmom or whatever, you've got an obligation to support those kids, and those kids have the right to be to benefit from your income and from.
Okay, but wait a minute. If the father of that child is already paying support, I don't have to pay support, do I?
Yeah, there's a good chance you're going to pay something.
Really?
Now, it might not be full support, right? It might not be full support as far as how we calculate child support typically. But yeah, step-parents pay support for kids.
So for child purposes, you could have more than two fathers, for example.
That's right.
How many fathers could you have in theory?
I guess it's unlimited, except maybe as to time, how much time a person has. So the case law does actually vary a little bit, all the way from the Supreme Court and the way it's been dealt with. There were some Supreme Court cases, and then Alberta Court of Appeal cases, and then there was this institution of what we call the child support guidelines, and now there's been some more cases, and the way that they deal with it has differed a little bit. But yeah, step parents, you got an obligation to support those kids.
So, and that's a good point. And the lesson is, if you're going to marry somebody with very young children, you need to understand that you're not just marrying them, but you're marrying their previous children if they live with you full time. And if things don't work out, there's a pretty substantial chance you're going to have a support obligation, not just for the children of your relationship, but for any other child that lives in your home on a significant basis. Now, so you list the kids and you list anyone who either of you is in a position of parent to during your relationship. And then you're going to propose custody. What do you put in there, Tyler?
Well, custody is going to refer to not just how you want to, what the parenting arrangement is going to be with the kids. It's more in depth. It's parenting rights about these kids and parenting obligations about these kids. And so typically we would want to share joint custody. Though that's an ideal situation where both parents are going to, or all parents, if you will, are going to be able to participate in the kids' lives in a meaningful way and make decisions. But if there's reasons that that's not possible, the relationship is such that it's just impossible to make decisions with that person, or that person has had little or no involvement with those kids for a particular amount of time. Lots of reasons that you might say, no, plaintiff wants to allege that they want sole custody. So I guess that's a decision you got to make.
So does joint custody mean that you're going to have the kids the same amount of time?
No. So that really the custody portion is going to refer to the rights and obligations of the parent, not just in relation to parenting time. It's going to be more about decision making for those kids.
Okay. So the way I usually describe that is, and I think you're right, it's becoming very infrequent that somebody's going to seek sole custody.
Yeah.
And you have to ask yourself, seriously, why do I want that? And there better be some significant departure from normal parenting regimes.
Mm-hmm.
Not just my husband or my wife is a jerk. The court typically starts with a presumption, really, of joint custody. I mean, both parents have the right to an active and involved relationship regarding what their kids are going to be doing. But you want to define, after you say joint custody, so what? Do you want the kids to be with you most of the time, all the time, half the time? And so quite frequently, it'll say something like joint custody with primary care to the plaintiff, meaning that the kids will live with you except when they go visit the other parent. Mm-hmm. But you're both parents. So, or joint custody with de facto care to remain with the plaintiff, or joint custody with full-time care to remain with you, the plaintiff. Alternatively, joint custody with equal shared parenting time between the parents. So you need to be very clear in what you want to establish if the court accepts your sort of perspective on how the kids should be parented.
And you'll see this if you're going along the form with us. You'll see that there's a place to put this stuff.
Yeah. And then the next paragraph will be the plaintiff proposes access or parenting arrangements for each of the children as follows. And that's where you really are going to say, well, what should it look like in terms of contact with the other parents, or how would we split the time? And so you could say, well, primary care with the plaintiff, the defendant to have every other weekend, or 4 days every other week, or one night, 1 week, and 3 nights the other week. You can be a little bit creative in there.
Yeah.
But that's what you're looking at. How do you want that? Now, you might just use, quite often parents are fluid and cooperative, and it often will say reasonable and generous access or parenting time with the defendant, meaning whenever we work it out, that's what it'll be, and there's no defined. So you could be defined or you could be general. That's up to you. And then finally, it'll say the plaintiff proposes financial arrangements for each child as follows. If you have a specific arrangement, you should know that it has to comply with the child support guidelines. So you're going to want to look up child support guidelines and compare the other party's income to what you've agreed. And if the guidelines say, based on that parent's income, that he or she is supposed to pay $900 a month, you can't agree that it'd be $400 a month. The court won't accept it. They have an obligation, except in very rare circumstances, to comply with the guidelines. Now,
that's because it's not a fight between the parents on that. That's a right of the kids from each parent. And there are sometimes some reasons why we might depart from the guidelines, but it's not going to be much, and it's going to be for some significant and specific reasons only.
Yeah. And I think the idea is to take away the extortion power of the non-primary parent.
Exactly.
You know, I'll pay you $200 a month, or else I'm going to make your life a living hell.
Yeah.
No, you're going to pay what the guidelines say you're going to pay, and you should know that that's not the choice of most often the mother, it's the law.
Right.
Now, if you don't know what the other parent makes yet, and that's not uncommon when you start your divorce because you haven't got complete disclosure yet, you could say in there, child support in accordance with the child support guidelines. And then you figure that out later once you get the disclosure.
Yeah.
So if you don't know, you can just say that. Child support in accordance with the child support guidelines. That's my typical, what I say.
Yeah.
I very infrequently will put a specific amount in that area.
Yeah.
Is there any agreement that you've entered into? An agreement means formal agreements. It doesn't mean my husband said he's going to pay me $250 a month for the child. Do you have a written agreement of some kind? Really is what paragraph 7 is looking for. If there is, indicate what the agreement provides for in terms of parenting support for the children and each other. And then paragraph 8 talks about prior court proceedings. The court wants to know, have you been here before, or is there another action ongoing at the present time?
In that court or a different court. Yeah.
Yeah. So, so you fill that in. Well, you know, we filed for divorce 2 years ago, but we reconciled and proceedings were discontinued.
Or we've been fighting about parenting for the last year in provincial court, and now here we are trying to get a divorce. Yeah.
And then the court wants to know about spousal support. You're claiming support for the following reasons. Or the plaintiff is not claiming support from the defendant. Or the plaintiff proposes support for the defendant as follows for the following reasons. I find that one of the more ridiculous provisions of our pleadings because particularly for self-represented litigants, the Supreme Court of Canada has over time developed a litany of reasons for getting support. There are different arguments about what support's based on. And to ask a self-represented party to fill that all in on your pleading, or even for a lawyer to put that all in there the first day you're filing for divorce is, I think, kind of a little bit ridiculous. I think all that you really should have to plead is that you want support because you feel you're entitled to it. And my pleadings almost look like that. Plaintiff is seeking support because the circumstances of the parties are such that it would be appropriate for the defendant to pay support to the plaintiff. I'm not going to get into the 30-page argument that you'll ultimately put before the court if you have a contested matter. I want support because I think the circumstances of the relationship are such that it's appropriate. If you're self-rep, put that in. You'll be fine.
That's good. Good advice. Yeah.
Or if you want to propose support for the other party, and sometimes that happens. You want the divorce, but you're going to pay support to the other person. Again, you can say, I'm proposing to pay the other party $500 a month because they make less money than me and they're looking after the kids primarily, or the circumstances of the relationship are such that that's an appropriate amount. You don't need to get too technical, in my opinion, at that point. And then once you've filled all that in, you get to remedy sought. And there's, again, checkbox. Well, I want a divorce judgment. I want access, custody, and parenting arrangements as above. And then if you have kids, child support. Do you want child support predating the claim? You can ask for retroactive support. As a rule, the Supreme Court of Canada has said you can go back 2 years if there's been no support paid, or you can get adjustments back. As a rule, 2 years if inadequate support has been paid since your separation. So if you want support before you're filing a statement of claim, you can claim retroactive support. You can also claim retroactive support for yourself and ongoing support. And if you want to seek a restraining order, you can fill that in. We'll talk about that on another day.
We will.
But that's a serious issue, and there are reasons you may or may not want to get a restraining order. But if you think you want one, you check that. Other relief, as a self-rep, I probably wouldn't worry about that. And costs, if there's no arrangement as to who's going to pay for the filing fees and that sort of thing, you can claim costs from the other party. That's up to you. Now, if you have a lawyer, the lawyer has to fill out a statement saying that they have complied with the requirements of Section 9 of the Divorce Act. Self-rep doesn't have to worry about that. And then it tells you that you have to serve this. So that's all the information on filling this thing out and some of the reasons why those things are there. You then complete this. You're going to make 3 copies. You take that into the Court of Queen's Bench. You pay them the filing fee. It says $260. Is that right?
I think it's 260. Yeah.
$260, and they stamp it, little court stamp, and they give you back 2, and you're going to want to deliver one of those to the other party. And
anybody in the world can do it except for you. Yeah.
Everybody but you. The plaintiff cannot affect service. You also typically need a photograph of the other party so that the person who serves it could look at the photo and know that you didn't just serve your brother or your best friend, you actually served your husband or your wife, as the case may be. And then they need to complete what's called an Affidavit of Service, and you can go online, it'll show you how to do that. But once they're served, if it's in Alberta, they have 20 days to file a defense. And if they don't, you can go ahead and make your application for divorce, and we can talk about that another day, or you can look online. It'll give you a little information on how you put that together. If you are served outside of Alberta, it's 1 month. 2 months if served outside of Canada. Now, I don't want to get into this in great detail, but if the defendant is outside of Canada, you need to get an order allowing you to serve outside of Canada. You can't just do it. And it would be a little complicated to go through that today. But you basically have to satisfy the court that you have a good action here, that this is a proper jurisdiction, that the other person happens to be outside of Alberta or outside of Canada, and where exactly they are and what you're proposing in terms of service. If you're not going to serve them personally, you have to provide a reason why you're not going to serve them personally, and that it would be inconvenient is not a good reason, that it would cost $50 is not a good reason. Really, you have to establish that it would be very, very difficult.
And likely that you've already tried to do it.
Yeah. Typically, you make the effort to serve personally, and only if you fail do you then go back to court and get an order for substitutional service. So that is basically how you file a statement of claim for divorce. We've taken half an hour to kind of explain that. I hope it was a little bit helpful.
If you guys want further information on how to do this, or how to file a defense to it, or how to serve it, or what to do after you've done this, contact our firm. Like I said, I'm going to start these seminars pretty quick here, and we can get you registered for my seminars, which are going to be coming up soon.
Yeah. Now, I should say, disclosure, I am the advisory board chair for the National Self-Represented Litigants Project, but the proposal to put together seminars for self-represented parties was Tyler's idea. I didn't push him in any manner, and so I want to give him all the credit for that. I hate to say it, I've been with the NSRLP for probably a decade, and it took Tyler to come up with, why don't we see if we can help out self-reps in our own area.
Well, and I'll pass the credit on to the people who are watching that know that they have spurred me in that direction. I won't mention names, but some of you know that you've spurred me in that direction. So
thank you to Tyler for doing that.
Cheers.
Cheers. So that's our spiel for today. Anything else we want to talk about today?
Nope, I think that's good. The last little thing I could mention is, look, at the very bottom of that document that we talked about, the statement of claim, there's a place and it says you can respond by filing a statement of defense. You have to put the city, the jurisdiction, the city where they can file the defense, the same city that you're filing.
But if you do the drop down, it fills it in automatically for you.
Perfect. Oh, okay, good. There you
go.
go.
Up at the top where you said my judicial center is Lethbridge,
It'll
once you do that,
at the
it
bottom.
puts Lethbridge. If you're in Red Deer, Medicine Hat, it'll do that for you.
Perfect.
So that's kind of a nice thing with the court documents. I mean, I think it could be a little bit clearer, and the law could be a little less obtuse in some ways, but definitely easier now than it was 30 years ago.
Yeah.
That's kind of our spiel for today.
That's good. Good timing.
Yeah.
This is fun.
Yeah, it's good.
Good.
Any plans for the weekend?
I have to work a little bit this weekend. I got a few things I got to catch up on. I got a court action that's somewhere between here and British Columbia, or maybe both, that I'm working on. So yeah, I gotta get that sorted out a little bit. How about you?
I have a little bit of work, but nothing major. Going golfing tomorrow, first time this year, distanced.
Very good.
I'm going with my dad, so we can't share a cart.
It's
kind of shitty because I kind of like driving along with my dad and chatting about this, that, and everything. But
Yeah.
Still nice that we're gonna get out. And,
Yeah.
yeah, we're gonna do a little bit of yard work. Cut my lawn yesterday. So,
Good.
so,
Hopefully it's not too wet, but good luck.
thanks everyone. Have a good
All right.
week, and we will see you next week.
See y'all next week.